Kindly adjourn the matter for today only, my lord. Item 1.
Charge-sheeted matter, Lordship, and repeat.
Lord, can it,
Why you are break for it?
my lord, some difficulty.
But Mr.
You Khan.
EU have that it appeal for it. Also heard it's a big up and addition for people. And the council for the petitioner has paid for an adjournment on the ground of personal difficulty. Let this matter be listed. The second week on the date.
Oblig.
In the next week.
Next.
Very good, sir. I beg to mention item number 24, 6 at 2 p.m.
No, we'll go as per period.
Scenery is another code for hearing.
No, it will come. It will take time to reach 20.
24.
We will not take that.
Last item. Last.
We will call it thoroughly. It will come on its own turn.
Yeah, please, Your Worship. I beg to mention item 4, my lord. I want to withdraw. The person already has been arrested, my lord.
Not Mr. A. Sikdar,
S.A. Sikdar.
S. H. Sikdar, Learned Counsel for the petition, who praised for allowing to withdrawing the instant anticipatory bail application as the applicant has already been arrested. Considering the fact that the anticipatory bail application has become infected with bail, this application, this anticipatory bail application is dismissed or withdrawn.
May it please, your lord. Lordship, 483 BNS application, my lord. This is second time application, my lord.
What is the offense?
My lord, NDPS commercial quantity, my lord.
Charge-sheeted,
Charge-sheeted matter, my lord.
Why second time?
My lord, first time it was disposed on merit, my lord. Now we are in delay ground, my lord.
How much? What?
Petitioner is behind the bar since 1 year, 6 months, 26 days, as on today. At this stage, kindly call for the record.
Heard
Mr.
UU Khan.
UU Khan, Learned Counsel for the applicant petitioner. Also heard Mr. M. A. Begum, and the petitioner public prosecutor. Perusal of the records of NDPS case number 35 class 2023 would be necessary for consideration of the instant bail application. Hence, call for the scanned copy of the aforesaid records. Let the registry to take steps for requisitioning the aforesaid record. Let this case be listed.
My lord, can it be fixed on 25, my lord?
25th of
Oblig.
May it please the Lordship. My lord, a regular bail application. My lord, arrested on 19/10/24. Allegations, affair is at page 11.
What is the offense?
Fake
Well,
gold and fake
Fake currency, cheating by deceiving, criminal conspiracy, and
Case diary would be
Okay, then.
heard Mr. P. K. Roy Chhatwal, Learned Counsel for the petitioner. Considering the nature of offense involved in this case, the result of the case diary would be necessary. Hence, call for the same.
Serene Lordship after Lordship 27 Lordship.
Let this case be listed again on 27th of
Due to
May I please, Lordship? Lordship, anticipated bail application, Lordship, it is suscited case, Lordship.
Charge sheet is case,
Yes, Lordship.
and why anticipated bail?
Lordship, case 13 is the FIR,
What
Lordship.
is the offense?
Offense under section 10,
Not section, what is the offense?
Lordship. As per allegation, Lordship, the uh, the petitioner attacked upon the informant, Lordship.
Assaulted him, Lordship.
Page
Uh,
40,
I-
page 13, Lordship.
Injuries
Grievous-
in my
gri-
head, left hand, forehead and right hand,
Grievous injury.
Lordship.
No, Lordship.
And that is
Page-
Lordship will reflect from or Thursday.
Lordship,
Medical assist.
yes, Lordship.
Medical-
Lordship, page 19 is the medical report, Lordship. Injury nature is simple, Lordship. Page 19. Then, Lordship, charge sheet, Lordship. Page 22, annex
A
of.
sharp weapon, Lordship. One is sharp and one is blunt.
But, Lordship, the petitioner,
Here may be called for Lordship.
No, just a- where is the rejection order?
there is no rejection order, Lordship. Page 22 is the charge sheet, Lordship. The police issued notice to the petitioner, Lordship. Accordingly, petitioner appeared and they let them go. Police allowed to go them bail, Lordship. Then, Lordship,
Or
Oh, the-
this is anticipated bail?
pending before the CGM, Lordship, for appearance, Lordship.
You appear
Now-
before the court.
Yes, Lordship. Lordship, page 30,
Whether court
Lordship.
has issued any
Yes, Lordship. Notice has been issued.
summons have been issued.
Yes, Lordship.
Then where is your apprehension?
Lordship, since the offense is session tribal, Lordship, the session tribal, Lordship, and CGM has issued the notice, Lordship.
Where, what is the offense?
Offense under section 109 and 118, Lordship.
109 is abatement.
No, Lordship. 109 is the Lordship under BNS, Lordship, attempt to murder.
307.
Lordship, page 39, Lordship, I have annexed an order, Lordship. Similar order may be passed. Lordship.
On perusing the LCR, Lordship, along with the search sheet.
Herein, Lordship, charge sheet, I have annexed, Lordship. And Lordship, page 23, Lordship, page 22, Lordship, charge sheet, Lordship. For moment, Lordship, may be pressed, Lordship. Page 22, second part.
Whose bail order is this? At page 30. Co-accused.
No, Lordship.
No,
A
Lordship.
separate case. Different
Another
case.
case, Lordship.
How
Similar,
it is relevant?
page 39, Lordship. Lordship, I am paying for similar order. Since
Lordship,
it's a
LCR
charge
may
sheet
be called
case,
for Lordship. Similar.
Lordship, kindly peruse the charge sheet, Lordship. Page 22, second part, Lordship. Relevant portion, page 23, Lordship. Already our statement has been recorded by the police.
What is your name? Azmat
Yes, Lordship.
and two others.
Hearing, Lordship, Azmat Ali and Zakir Ali.
Third, Mr. What is your name?
Yes, Alon.
Yes, Alam, Learned Counsel for the petition. Also, heard Ms. A. Begum, Learned Additional Public Prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners who are apprehending their arrest in connection with who are apprehending detention in connection with PRC case number 297/2/2024. So it is pertinent to note that in this case, charge sheet has been laid and summons have been issued to the petitioner. However, the petitioner apprehends that as offense under section 109/118 within bracket 2/3 within bracket 5 of BNS is involved, the court of learned magistrate may not grant bail on their appearance. So, considering the nature of offense involved in this case, perusal of the case diary of Kokrajhar PS case number 163/24 would be is felt necessary. Hence, call for the scanned copy of the case diary of Kokrajhar PS case number. No, you can produce the case diary from
Lordship, it is charge sheeted, Lordship.
still because charge sheet in the record, nothing will be there. We have to see their involvement.
Lordship, once it is charge sheeted, Lordship, the case diary is submitted to the court, Lordship, the registry will.
Yes. From the court of learned Chief Judicial Magistrate Kokrajhar, registry shall take steps for requisitioning the aforesaid scan copy. List this matter again on. When is the date fixed for the court?
Lordship, today is the today, Lordship. 8/11, Lordship.
Then you have to appear before that. Fix on 25th of November.
Lordship, so far my humble submission, Lordship, case 23, Lordship. The petitioner appeared before the police, Lordship. Their statement already has been recorded. And they were allowed to
You were not arrested.
know, Lordship. So,
You
Lordship,
were not on anticipatory bail.
no, Lordship. Since, Lordship, the police allowed to go me from the.
Let us see. Let us.
It is so clear from the charge sheet. Case 23.
25th.
25th.
Obliged.
Repeat. Nine. How people talking to?
Yes, please. sir.
For item H, Lordship, for information.
We'll take it up after,
Yes.
Lordship,
after,
After sunset.
at 2.
Lordship, please.
Okay.
Today is Friday.
Okay.
Oh.
Morning, Lordship. This is 482 BNSS application item number 9. I am appearing for Safiq Islam and Abdul Rafiq.
What is the offense?
May I only go to page number 13, that is the vernacular FIR.
Murder.
Gambling, Lordship.
Not,
Yes.
not,
Well, is it Niki?
Yes.
No, sorry.
that is punishment for murder 103, 238 and 61. That's criminal
I
conspiracy.
came to know that one unidentified dead body was found at Bakhatao Gaon, under Rupohi police station, recovered by the staff police. My brother then collected the photo of the dead body of the person when there is a that the dead body was my husband. The dead person was my husband.
Why are you apprehending your arrest?
You know, the FIR was lost after 11 days. There are 4 accused in the FIR. I am appearing for the 1 and 2.
Or named, you are named in the FIR.
Yes, my lordship. But,
See the lordship,
Case
But-
diary.
case
but-
diary.
no, you know,
Yes, yes.
the informant has filed the FIR on doubt. It is shown in the FIR on the last page.
What is your name? Rafi.
Rafiq and Safiqul. I'm appearing for the 2. There are 2 accused, for 4 accused. I'm appearing for the 1 and 2. শ্ৰমিক বৰ্তমান উক্ত আসামীজন মোৰ স্বামীক হত্যা কৰি পেলাই যোৱাৰ সন্দেহ হৈছে on the last. That is on the page number 14. It has been in the FIR, mentioned in the FIR.
FIR may be read,
Yes,
Then-
please read the,
full FIR.
read the FIR.
Yes, my lordship. এজাহাৰকাৰী চাৰিফা খাতুন, আসামীগণ শফিকুল ইছলাম, ৰফিক আহিদ জামান উৰ্ফে আহিদ, আৰু 4 নম্বৰ হ'ল উছমান আলী। সন্মান সহকাৰে আপোনাক জনাওঁ যে যোৱা 6/9/2024 তাৰিখে বৰঘাট নিবাসী আব্দুল জলিল তৃতীয় পুত্ৰ মোৰ স্বামী মতিবুৰ ৰহমানক জিয়াও মাৰি সুৰজ আলীৰ পুত্ৰ আছুদুল্লাই অবৈধভাৱে জুৱা খেল দিয়া স্থলত আছুদুল্লাই মাতি নিয়ে। এই স্থলত 3 নম্বৰ আসামীজনে মোৰ স্বামীক লগত জুৱা খেলত প্ৰথমতে তৰ্কাতৰ্কি, তাৰ পিছত চোকা অস্ত্ৰৰে প্ৰাণ মাৰাৰ চেষ্টা চলায়। সেই সময়ত জুৱা খেলত উপস্থিত থকা কিছুমান ব্যক্তিয়ে মোৰ স্বামীক উক্ত আসামীৰ পৰা প্ৰাণ ৰক্ষা কৰি ঘৰলৈ উভতিয়াই পঠিয়ায়। ওপৰত উল্লেখ 1 নম্বৰ আসামী 3 নম্বৰ আসামীজনৰ ডাঙৰ ককায়েক হয়। সেয়ে মোৰ স্বামীয়ে খঙত ৰাতি 3 নম্বৰ আসামীজনৰ ককায়েকৰ নাওখন নি আমাৰ ঘৰৰ সন্মুখত পানীৰ তলত ডুবাই থৈ দিয়ে। ঘৰৰ অহাৰ পিছত মোলৈ ফোন কৰি কান্দি কান্দি কয় যে আহিদ নামৰ মানুহজনে জুৱা খেলত মোক প্ৰাণে মাৰিবলৈ বিচাৰিছিল আৰু মোক স্পষ্টকে জনায় যে মোৰ যদি কিবা অঘটন হয় তেন্তে জানিব আহিদে কৰিছে। আহিদ ইজ দ্য 3rd নম্বৰ accused. ওপৰত উল্লেখ 4 নম্বৰ আসামীজন 1 নম্বৰ আসামীৰ শ্ৰমিক হয় আৰু তাৰ পিছদিনাখন 7/9/2024 তাৰিখে ৰাতিপুৱা 4 নম্বৰ আসামীজনে নাওখন বিচাৰি আমাৰ ঘৰৰ সন্মুখত পায় আৰু লগে লগে 1 নম্বৰ আসামীজনক জনায়। তেতিয়া 1 নম্বৰ আসামীজনে 4 নম্বৰ আসামীজনক আৰু তেওঁৰ ভাই ককায়েকে হুকুম দিয়ে যে মতিবৰক যেতিয়াই পাৰে তেতিয়াই কাটি এচিড ঢালি দিব। সেয়ে 4 নম্বৰ আসামীজনে চিঞৰি চিঞৰি 1 নম্বৰ আসামীজনক কোৱাৰ দৰে কয়। অলপ সময় পিছত ৰাতিপুৱা 6-7 মান বজাত মোৰ স্বামী ঘৰৰ পৰা ওলাই যায়। সেই সময়ত 4 নম্বৰ আসামীজনে মোৰ স্বামীক উদ্দেশ্য কৰি পিছে যোৱা বুলি মানুহৰ মুখে মুখে ওলায়। তাৰপিছত মোৰ স্বামীৰ লগত মোৰ ফোন যোগ
We are
গোটেই দিন
calling for the case.
Case diary, only case diary.
Case
lordship.
diary.
So, lordship.
No, we are not giving long day.
Hmm.
We are giving short. Heard Mr. P.K. Chetri, and it's counsel for the petitioner. Petitioner also heard Ms. A. Begum and the additional topics.
20 lordship.
Considering the nature of offense involved in the case, the result of the case diary is felt necessary. Hence, call for the same. List this matter again.
2011 lordship.
20.
This is of anticipatory appeal, lordship. In this case, the petitioner has been alleged that he has kidnapped the informer. Thereafter, he has taken her to Helem, under Helem police station, whereafter he has wrongfully confined her, raped her, and had made videos of her. And after that, she has been rescued by her family relatives, Your Honor. And but the case of the petitioner in this case is here, both the informant and the petitioner, Your Honor, both are having an extramarital affair from the year 2021 itself, Your Lordship. This can be proved, Your Lordship. If Your Lordship comes to
application. The prayer is without this case is dismissed.
with the liberty to file it.
Liberty is not necessary. Your liberty is always there to approach this court if you are under arrest.
Hang on.
May I please repeat? Firstly, respondent two was my wife, who filed a FIR against me during 2013, which was at Nagaon Lordship.
2013.
13 Lordship, under 498A. Thereafter, the said FIR transferred to Bongaigaon. Thereafter, it was registered at Bongaigaon. Thereafter, I obtained anticipatory from Honorable this High Court, myself with all my family members. There it is charge sheeted. Thereafter, during before charge sheet, I filed on criminal petition for 82 before this court, which was I withdrawn. Thereafter, case started for evidence. During after completion of evidence, prosecution filed a petition 319, which was rejected by the Honorable CJM. Thereafter, against that rejection order, they came before this honor for criminal revision, which was partly allowed. After that petition, my brother and my father was the accused on that case. After hearing this, my father expired. Then my brother went to Supreme Court challenging this order of this Honorable High Court. During that time, my wife,
Order in revision,
yes, the or in revision, it is partly allowed.
where 319 petition
Yes,
was allowed.
yes, in High Court, it is partly allowed. Out of four, my brother and my brother was accused from this case. After hearing my father expired, my brother went to Supreme Court. After went there, my wife and myself, we amicably settled the matter by a memorandum of understanding that we will go for divorce. And that was done. Then we filed a divorce petition in Nagaon's district judge. That divorce was allowed. In MOU, there is a condition that both the party will withdraw their all the cases. So accordingly, my brother withdraw the case from Supreme Court. But my respondent who was my wife, she has not withdraw or not coming before the trial court CJM Bongaigaon for re-examination, that she has no grievance like that. Like this, it is pending 2003. And I myself and my mother has to come before the court in all the days. So last occasion 1410, Honorable CJM notice was served to respondent two, but she has not turned up. So against this order, I can refer honor. So this proceeding may be stayed and she may be called for here. This is my case, Lordship.
No, where there was mutual agreement,
Yes,
in
Lordship.
the family court.
No, Lordship. It is District Court Nagaon, Lordship. You will find, Lordship, come page 53, Lordship. Memorandum of Understanding 53, Lordship. This is we prepared, and on the strength of that, we go for a divorce petition. Page 56, Your Lordship, para 3.
Now she is divorced.
Yes, Lordship. In 19, we got divorced and I paid 30 lakhs to her. She's working in State Bank. I am a doctor, Lordship. Thereafter, I got married, but only the issue.
Where is the stipulation that we will withdraw all the cases?
Yes, Lordship. Page 56, para 3, Lordship. Page 56, para 3, middle portion, Lordship. The younger brother, yes, please. The younger brother, first party, namely Pias Roy, shall also make these efforts all get to SLP bearing number so and so, disposed of by the Honorable Supreme Court at the earliest. And second party, in the light of the terms and condition of amicable settlement, arrive at in between the parties hereto for full and final settlement of all their past disputes and grievances arising out of their marital relationships, shall put her sincere efforts and shall take all necessary steps for lawful acquittal of the first party and all other accused persons of GR case number 364/203 by appearing in person before the Honorable Court of Chief Judicial Magistrate Bongaigaon and or when summoned, Lordship. So accordingly, Honorable CJM is issued summon, but she is not coming, Lordship. Last it is fixed on 14, Lordship, 1410. And you see, in divorce petition, divorce order, Lordship. Yes, Lordship. And this agreement made a part of degree of the case, Lordship. Yes, Lordship, page 63.
Okay, heard Mr. Dilip De, D. De, Learned Counsel for the Commissioner. This application under section 528 of BNSS 2023 has been filed. How many petitioners are there?
Two petitioners, Lordship, myself and my mother.
By the petitioner for quashing of the proceedings in proceeding of GR case number 364/2023 pending before the Court of Learned Chief Judicial Magistrate Bongaigaon. State proceeding was initiated on the basis of an FIR filed by respondent number 2 on 28/4/2013. Learned counsel for the petitioner has submitted that there were other litigations pending before the litigations between the parties pending in various courts. And one of such case was pending before the Court of Learned District Judge.
Nagaon Lordship, that was,
Nagaon.
yes,
That is the
that is decreed Lordship,
divorce
yes.
suit pending before respondent,
But no Lordship not pending the disposed Lordship.
no, which was there before, which was for divorce between the respondent, between the petitioner and respondent number 2. In that divorce suit, an amicable settlement was arrived at between the parties, and a memorandum of understanding was executed. So one of the terms of settlement between the parties in the said memorandum of understanding was that they shall settle all their litigation arising out of their marital relationship, including the GR case number 364/2013. So, on the basis of said memorandum of settlement, the divorce suit was decreed on compromise. Learned counsel for the petitioner has also submitted that the brother of the petitioner,
Pias Roy,
namely
Pias Roy,
P.
Pias,
Pias Roy,
Roy.
who was also made an accused in the GR case number 64/2013 on the strength of an application under section 319 of CRPC. So, the brother of the petitioner had approached 319 of CRPC, against which the who preferred revision before this court?
this by the respondent too. Their 390 petition rejected.
That
Yes.
what was the matter? No. I would like to cut it. No, accused under section 319. It's not cut. Accused under section 319 of the CRPC, when the revision petition filed by the respondent number 2 was partly allowed by this court
This court.
in
In criminal petition number.
criminal petition number where is that?
214/18, page 48.
214/18 page
214/18.
48. Stop. The brother of the petitioner had referred an SLP before the Supreme Court against the order of this court passed in the criminal petition number 214 slash
18, 19, 18,
249
214 and oblique 18.
49 slash 2018. Now, in the Supreme Court,
We withdraw after the memorandum agreement and divorce, we withdraw as
Oh.
per
however,
page 64.
he said a SLP was withdrawn
Hmm.
by the brother of the applicant.
Yes.
After execution of memorandum of settlement between respondent, between the petitioner number 1 and respondent number 2. Stop. Learned counsel for the petitioner has submitted that now the petitioners are appearing before the trial court in GR case number 364/2013. However, respondent number 2 has not appeared
Yes.
in spite of repeated events of
Yes.
summons to her. Stop. Though the respondent number, it is also submitted that the respondent number 2 was the signatory of the memorandum of understanding executed with in between the parties on 2nd day of August 2019. Stop. Let the notice be issued to the respondent. The petitioner shall take steps for issuance of notice on respondent. No, before that, as Mr. R. Kaushik has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2, the petitioner shall take steps for issuance of notice by registered post with AD as well as by usual mode within 7 days from the date of this order. Stop. Considering the submissions made by learned counsel for the petitioner as well as facts of this case as narrated herein before, the further proceeding of GR case number
364.
364/2013 pending before the Court of Learned
CGM Bongaigaon.
Chief Judicial Magistrate Bongaigaon shall remain stayed till the next returnable day.
Okay.
List after court.
Mayor, your lordship, and this will be bail, your lordship will find FIR at page 7. May I read, madam?
What is 108 BNS?
108 days suicide.
Oh.
Abatement of suicide.
Yes, read the affair.
Yes, I have the honor to inform that my younger sister Sultana Khatun is a student of HS second year of Assam Jyoti Junior College, Juradia. My sister Sultana Khatun has taken poison at home on 18/9/24 and thereby got fainted. Immediately she was taken to Dhekajuli CHC, but the medical officer referred for better treatment to Tezpur and accordingly admitted to Gate Sukhoda Institute Multi-Speciality Hospital, where necessary medical treatment was provided but died there on 19/9/24. The dead body was thereafter sent to Tezpur Medical College Hospital for postmortem after having obtained permission so and so, so and so, so and so. Sir, we have come to know that there was affairs for 3 years in between the accused and my sister. Numbers of phone calls were made yesterday.
Why are you apprehending your arrest?
Hello.
Because you are named in the affair.
Yes, I have been named in the FIR. And the 108 said that whoever commits suicide.
Heard Mr. BC.
Yes.
Let him appear.
Madam.
Heard Mr. BC. BC in Learned counsel for the petition. Also heard Mr. R. Kaushik, Learned petitioner for the public prosecutor. CD would be required. Or can we dispose it off?
No, let the city call.
This application under section 482 of VNSS 2023 has been filed by the petitioner Safir Uddin, who is apprehending his arrest in connection with Dhikia PS case number 180/2024 under section 108 of BNS 2023. Stop. The gist of accusation in this case is that one, Muqsidul had lodged an affair on 19/9/2024. Muqsidul Islam, Muhammad Muqsidul Islam, had lodged an affair on 19/9/2024, inter alia, alleging that his sister Sultana Khatun had committed suicide on 18/9/2024 by consuming poison stuff. It is also stated in the affair that as the accused, as the present petitioner was having an affair with the victim, he suspected that the accused, that the present petitioner might be involved in abetting the victim to commit suicide. Stop. Learned counsel for the petitioner has submitted that the FIR has been filed against the present petitioner merely on the basis of suspicion, and apart from suspicion, no other material is there against the present petitioner. Stop. On the other hand, learned additional public prosecutor has submitted that perusal of the case diary may be necessary for consideration of the instant bail application. Stop. Hence, call for the case diary. When can you bring case diary?
Well, on 26/11.
Let the case diary be called for fixing 26/11/2024. Stop. In the meanwhile, considering the fact that the affair appears to have been lodged against the present petitioner mainly on the basis of mere suspicion, the present petitioner, namely Safiruddin, in the meanwhile, is directed to appear before the investigating officer of the PS case number 180/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the PS case number 180/2024, he shall be allowed to go on interim bail of ₹30,000 with one surety of life, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1. Let this case be listed again on 26/11.
Sir, item number 13 scan copy received, but it was not shown in the post list, so I could not go through the scan copy.
NDPS,
Yes, ma'am.
Minus, can it be fixed on Monday, madam?
Let it be Tuesday, madam.
Tuesday?
Tuesday, madam.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner, also heard Mr. R.R. Kaushik, learned additional public prosecutor, who submits that he who prays for some more time for going through the scan copy of the case record received from the trial court. Stop. The prayer is allowed. Let this case be listed again on
12th of November, madam, Tuesday,
on 12th of November.
on DPO.
14th, he did not receive my.
Info case take political. None appears for the applicant petitioner on call. None an additional public prosecutor prays for some more time for producing the case directly with the law.
On 18/11, my lord.
Let this case be listed on 18th of November 2020.
Yeah, please, Your Lordship. Case diary has been called for minor.
15 also,
correction.
he did not receive my lord.
This is from Bayhata Charlie, man. Can
Wait,
be on 11th,
In
minor.
order. Heard Mr. D. Bora, learned counsel for the. Also heard Mr. R. Kaushik. The learned additional public prosecutor takes some more time for producing.
On 11th, my lord.
On 11th, minor.
Let this case be listed again on 11th of
11th.
November.
Obliged, madam.
May I please, Lordship? Lordship, on the earlier occasion, scan copy was called, Lordship, and Lordship, we
And copy has not come.
Not come.
we pray for issue of reminder to register, Lordship. And
Heard, what is your name?
Lordship, HD Das.
Heard Miss H. T. Das, learned counsel for the petitioner.
Lordship,
Also-
fixed date maybe.
Also heard Mr. R. R. Kaushik. On perusal of the office note dated 7/11/27, it appears that the scanned copy of the case records which were called for have not yet been received. Stop. Issue reminder. Registry to take steps for requisitioning issuance of reminder for requisitioning the scanned copy. Let this case be listed again on
For short date.
which is the court from where the
Supreme Court of that.
25th of November.
I have that, Lordship.
My lord, 16, he did not receive my lord.
None appears for the petitioner on call. An additional public prosecutor has. He is on interim bail.
Yes, my lord.
None appears. Prays for some more time for producing the case. There is allowed.
21st November, my lord.
Let this case be listed again on 21st November. The interim order shall continue till next day.
My lord, I am led by senior counsel Mr. T.J. Mohanto, my lord. Can be, my lord, after some time at 2 months.
Otherwise, after interim order, they appeared. my lord.
We have already appeared, in fact, my lord.
And-
You are opposing.
Yes, earlier I was appearing for the victims who were shareholder of the cooperative society, Samobai Samiti Limited. And now today I have filed wakalatnama for the informant who has lost the instant case. After getting interim order, the son-in-law along with one of the applicant Abdul Mateen had went to the office itself and tried to stab him in front of the office staff. Thereafter subsequent affair was lost. So they have violated the terms and conditions of the
Stab.
in the office itself.
Oh,
That is serious.
then
This false, my lord, I am, my lord, placing the, my lord, bail order of this petitioner, my lord, Abdul Mateen. In fact, my lord, in fact, that informant, he has been suspended because of his, my lord, false FIR and then transferred, my lord. Now he has been transferred, my lord, because of his false allegations against the, my lord, petitioner and other cases also, my lord, pending against him, my lord.
If
Elec-
this so, then I will require the arbitration.
so
my
that
lord.
stabbing, you are,
Not
Me-
me, my lord, not me, my lord.
that
This is
stabbing
the order, my
allegation
lord.
is false allegation.
Yes, that is it, reflected in the order itself. Your lordship may see it.
No,
That's-
let Mr. Mohanto come.
It is only to, my lord, implicate my name in that FIR, my lord. So nothing else, my lord.
And so far this saving is concerned, that is, in this regard, obviously, I will need the
Instruction.
instruction, because it is not that updated.
Regarding that case study,
It's not updated.
Record.
yes, I have given the FIR lordship may call for the case study of that.
That particular case also it will make clear, my lord.
Because the order is there that I do not know what is there written in the order, but your lordship may call for that case diary of that case also.
No. After appearing for informant, have you filed any,
Wakalatama, today morning I have filed. He has
Okay.
come today
no, how you are bringing it to the notice of the court by oral submission?
by oral.
Oh.
So,
Where will we know about the case?
that certificate copy of that FIR I have given to your lord, along with the type copy.
Up to date case diary is there.
My lord, it is not up to date, but
Stabbing allegation is against the petitioner who is on bail.
Abdul Motin.
No, no,
with
my
his
lord.
son-in-law.
No, let him.
yes,
Abdul Motin was also implicated and the step was given by his son-in-law. That is it.
I will show the bail order of that accused also. That is, my lord, reflected in the order by the session judge himself, that this is, my lord, something false. my lord.
Therefore, I'm saying lordship may call for the case diary of that case also. You can bring it.
How that case can be, my lord, brought it, my lord, along with this case.
Because this-
In that case, we have already been granted bail, my lord. Anticipatory bail by the, my lord,
Now you bring it on record by filing affidavit instead of oral objection. What is, or filing an objection to
Lordship may give me some time, I will write that.
objection,
I will bring it.
written objection. Heard. Mr. J.C. Bora, learned counsel for the petitioner. Also heard Mr. R.R. Kaushik, learned additional public prosecutor, as well as Mr. A. Ahmed, learned counsel appearing for the informant. Learned counsel for the informant, Mr. A. Ahmed, has submitted that while the petitioners were on interim bail by this court, granted by this court, the who
The petitioner Abdul Motin along with his son-in-law tried to solve the problem in his office.
the petitioner along with petitioner Abdul Matin, along with his son-in-law Muhammad Khairul Islam, tried to assault the informant Motinur Rahman. Who is the informant?
Motinur Rahman.
Motinur Rahman, by stabbing him in the office premises of, which is the office?
Uh,
Office of the Assistant Director of Food and Public Distribution, Morigao. And in that regard, an FIR has also been lodged by the informant on 26/9/2024. Stop. On the other hand, Mr. J.C. Bora, learned counsel for the petitioner, has submitted that the allegations made by the informant are false and the petitioner and his son-in-law are already granted bail. They are on bail.
yes,
Bail. Stop. In respect of the case which was registered on the basis of the FIR lodged by Motinur Rahman. Stop. Learned counsel for the informant has prayed for some time for filing a written objection in this case, bringing on record the latest, bringing on record the subsequent development and the allegations made by the applicant. The prayer is allowed. The when, how much time?
2 days. Expect any day for it.
When we will pick
Lordship is calling for the other.
No, not because FI.
Friday.
Next week Friday বন্ধ আছে।
And what is the progress in this case? They have appeared
They have appeared.
We have appeared and in,
and
my lord,
investigation is proceeding.
My lord, the city is up to date till August.
And one inquiry report was also called by your lord.
My lord, that last date of last update is on 21/8. My lord.
Learned,
Nah.
stop. Learned additional public prosecutor, on the other hand, submits that though the case diary of which case?
My lord, Lahorighat PS 142.
Lahirighat PS case number 142 slash 2024 is available before the court. However, it is updated only till the month of August 2024 and an updated case diary may be required in this case. Stop. The prayer is allowed. The petition, the additional public prosecutors shall send back the case diary to be called again after updation on
That case Lordship has fixed it or 25 or
29th
59.
29th of this month. Let 29th of November, 29/11/2000.
my lord, interim to continue, my lord.
The interim order shall continue.
Deeply obliged.
One item. 29 to 19.
But I am appearing in item number 20 and 21. My friend is appearing in item number 19. I'll be appearing in item 19. The Lordship permits, I may submit on item number 20 and 21.
What is the stage?
Well, the-
You all are on interim bail.
Yes,
Even they appeared pursuant to the interim.
You have appeared before.
they have appeared.
You have cooperated in the investigation. What is your submission?
My lord, they are corporate.
Then we are making it absolute. Common order Deepak. Heard. Mr. P. J. Soikia, learned senior counsel assisted by Mr. P. Bortole in AB 2190. Item number 20 and which matters you are appearing
And my lord, 2244.
in comma AB 2244. Only two
24.
cases. In two cases you are appearing.
Lodge.
Also heard Mr. S. Nawaz, learned counsel for the petitioner appearing in AB case number
2430.
2430. Stop.
Lordship. Lordship. When appears for the other two. I'm appearing on 2309, Lordship.
Also heard Mr. P. Bortole appearing for the petitioner in AB case number 2309 and
2365.
2365. Learned counsel for the petitioners have all the aforesaid anticipatory bail cases have submitted that. When were you allowed to go on common date or separate date?
Separate. My lord,
Oh.
I was allowed, my lord, 17.
Or just were allowed to go on bail, interim bail by this court. Stop. The petitioner, namely Dr.
Abu Sharif Akanda.
No, petitioner namely Salim Akhtar Chaudhary alias Salim, and who else was there?
Salim Akhtar Chaudhary, alias Salimuddin, and my lord, Mehboob Ahmed Borpia, alias Mehboob Ahmed.
Alias Mehboob Ahmed Borbhuya.
Salim Akhtar Chaudhary, alias Salimuddin.
No.
Mehboob Ahmed Borpia, alias Mehboob Ahmed.
Petitioners in item number 19. were allowed to go on interim bail on 17/9/2024. The petitioner, the petitioner in AB case number 2190, Dr. Abu Sharif Rakanda, was allowed to go on interim bail on
21/8/2020.
21/8/2024. The petitioners of AB case number 2244/2024, namely Muhammad Anwar Hussain and who else?
Islamuddin,
And Islamuddin, were allowed to go on bail on
28/8/2020.
28/8/2024. Stop. The petitioner of AB case number 2309/2024, namely Imdad Chand, was allowed to go on interim bail on 9/9/2024. The petitioner in AB case number 2365/2024, namely Hasina Begum, was allowed to go on interim bail on
Same date, 9/9/2020.
on 9/9/2023. Stop. Learned additional public prosecutor has produced the case diary of
Doboka PS case number
Doboka PS case number
148 of
148/2024, and has submitted that the above named petitioners have appeared before the investigating officer and their statement have already been recorded by investigating officer. Stop. It appears that the above named petitioners have complied with the directions of this court and have cooperated in the investigation. Stop. Hence, the interim bail granted to the above named petitioners by the orders referred herein before are hereby made absolute, with condition that they shall continue to cooperate with the investigating. With above observation, all the aforesaid 5 anticipatory bail applications are disposed.
In AB number 2430, my lord, there was a mistake in the cost title, my lord. So we had filed an IA. Your lordship was pleased to allow the IA. We filed a rectified cost title that has also come on record. Problem is that in the system, my lord, it has not been corrected. So the subsequent orders are still showing the erroneous
What is the error?
address. Address, my lord, if your lordship has item number AB 2430, the record has the corrected cost title, my lord, where the correct address is there. But in the system, my lord, that has not been changed. So when the certified copy order will be again generated, it will still show the old.
But there is an order for correction.
Yes, my lord, order is there. Yes, order is there, my lord, and we have also filed.
Mika, address can be corrected. Put corrected as per the. We'll correct. No order is required. If today it is not corrected after uploading, you verify.
My lord, will
Then you inform the court master. We will get it.
We have sometimes is coming.
Okay.
I have, if you're on behalf of report number 2.
This is a POXO case,
Yes, no,
376.
Next week, my lord.
In any case, my lord, they have not taken any new ground.
Yes.
Okay. You have filed wakalat number.
Yes, my name is.
You will be filing objection.
Yes, I will file.
Heard, Mr. What is your name?
Islam.
Heard, Mr. A. Islam, learned counsel for the petitioner. Also heard Mr. R. R. Kaushik, learned additional public prosecutor. Mr. A. Chaudhary,
Yes,
Mr. S. Islam, from our learned counsel, has, for the informant, has submitted that he has appeared for the informant today itself, and he will be filing written objection against the,
I believe
he will be, then why not today?
I have not put you.
Okay. He needs some time to go through the application for bail, and before he makes his submission objecting the prayer for anticipatory bail, and hence prays for some more time.
Let me fix. 13 November, CDs received.
CD receipt.
CD is there,
Yes,
let it be on 13th. Let this case be listed again on 13th of
November.
13th of.
Obliged, sir.
Sir, this is for suspension of sentence, but there has not been any objection filed. So if they're not willing, then my lord,
My lord will file objection.
For the response number, am I?
This is a POCSO matter.
Yes.
convicted for 10 years and in detention, under,
You will be filing objection.
Yes, ma'am. 10 years
When?
shortly, madam.
Let them file.
my lord, may kindly fix the date
Heard Mr.
as they know.
S. Day, learned counsel for the applicant slash appellant. Also heard Mr. R. Kaushik, learned additional public prosecutor, as well as Mr. D. K. Bhattacharya, learned amicus curiae, appearing for respondent number 2. Learned additional public prosecutor has prayed for some more time for filing written objection against the prayer for suspension of sentence filed by the applicant. The prayer is allowed. When we can fix it?
Any date, my lord, only last week for November.
Let this case be listed again on 28 November. Yes.
Much obliged.
Right, please, Lord. My lord, the petitioner before your lordship is a retired BDO man. And one FIR was lodged against him after his retirement that which do not constitute, my lord, any offense, my lord. It is FIR at page 13, my lord.
No, here will.
There is no
require the
allegation.
report, my lord. It will be required.
Is there, it has not been called for.
Maybe, my lord.
It is
As
private.
per my note.
It
was
has been
called-
called for. There is a order calling for the case diary. Case diary is not there.
Not received, my lord.
Case diary would be required.
A notice should go to the respondent number 2.
Notice is already served, my lord.
What is the offense?
My lord, page 13 is the allegation, my lord. This, my lord, there is no allegation, my lord. For criminal, my lord, proceeding, there must be one allegation, my lord. And
Let us see just a minute. Page 13.
it is to inform you that during spot inspection on 10/1/2018 of scheme under Honorable Chief Minister Beam project, namely so-and-so at Bourbon to be under Lala Development Work with an estimated cost of rupees so-and-so only already.
Allegation of misappropriation is there.
Yeah.
He is suspecting prima facie. No allegation, I have misappropriated. He has misappropriated.
No, obviously.
This
police
what
will
is not done.
investigate, my lord.
No, that kind of, my lord, there is a lot to be aware, my lord, that kind of accusation is not permissible, my lord. Here, my lord, he has stated that, my lord, one line, the following official and as per status of work, it is prima facie observed that government money was misappropriated by the following incumbent.
It will reveal that.
Case diary. Heard Mr. A.
A.M. Bodobia.
A.M. Bodmir, learned counsel for the petitioner. Also at Mr. R.R. Kaushik. Who submits that though the case diary was called for on last occasion, however, same has not arrived. And he prays for some more time for producing the case diary. Issue reminder for case diary. When then this case
27,
will not fixed date.
Date may be not.
Let this case be listed on 27th of
Obliged.
May it please your lordship. Lordship, this criminal petition under section 482 of the CRPC has been filed for setting aside the order dated 29/4/2024 by the session judge in criminal revision case number 1 of 2022.
2000.
1 of 22, lordship. Order impute on 29/4/2024, lordship. Lordship, if I may come to the facts in brief, lordship, before coming to the order, lordship.
No, where is the impugn order?
Lordship, impugn order, lordship, is at page from 93 and effective portion from 94. lordship.
93.
Effective portion 94, lordship.
It is a judgment.
Lordship.
Judgment.
Lordship, judgment whereby the order framing charges against the respondent number 2 was set aside, lordship.
In revision.
In revision,
Against that setting aside prayer you have come.
lordship.
Okay.
Lordship, if I may come to the facts, lordship, in brief.
Yeah.
Lordship, the petitioner, lordship, had approached the office of lordship, lordship respondent number 2, respondent number 2, who was the manager of MS Khazana Agriculture Equipments and Shiva Durga Finance Equipments in Kolkata, lordship. In the year 2000, lordship, in the year
The
2005.
petitioner,
Lordship, petitioner, lordship,
what?
lordship, he's engaged in the business of lordship supplying lordship power tillers, tractors, lordship of that kind. Lordship, therefore, he approached the office in Kolkata. The respondent number 2 was at the office. Under his instruction, lordship, the petitioner paid an amount of rupees 25 lakhs in favor of lordship Shiva Durga Enterprise. Lordship addressed to the respondent number 2, who was posing in as the managing director, lordship. A demand draft was provided, paid, lordship, and the same was encashed, lordship, with the understanding that 40 numbers of power tillers will be delivered to the petitioner at Mongoldo, lordship. Now, lordship, the tractors were never delivered, and the amount of rupees 25 lakhs was encashed, lordship, on the next day, lordship. If I may take your lordship, to page number 30.
Yes. Yes.
Page number 30, lordship. This is the translated page. On the next page is the original, lordship. Here, lordship, it is addressed to Mr. Anil Todi, who is the respondent number 2, Managing Director of Shiva Durga Finance and Investments, 5 Cleve House, Strand Road, Kolkata. Here, lordship, payment of draft of rupees 25,000 is this letter is regarding the payment of rupees 25,000.
25 lakh.
25 lakhs, lordship. Here, lordship, if I may read, here it's written, dear sir, kindly arrange to dispatch 40 numbers of Khazana power tillers, so-and-so model, against the payment of rupees 25 lakhs only of draft number so-and-so dated 17/3/2005 made by us. The above said draft will be paid at Kolkata, and now the same draft will be sent to you. I would request you to dispatch 40 numbers of so-and-so immediately within 20 March 2005 to carry the same from Kolkata to Mongoldoy, Assam, lordship. It is clear, lordship. It was deliverable at Mongoldoy. Now, Lordship, if I may take your Lordship to page number 33, page 33. This is an occasional acknowledgement from the ICICI Bank, Lordship. Here it is said that in reference to Lordship, application was filed to know as to whether the demand draft was encashed. Here, Lordship, it is acknowledged, wherein it says in reference to a letter about the encashment of DD white number so and so dated 17/3/2005, we confirm you that the above mentioned DD was credited to account so and so of Shiva Durga and Finance and Investment on 18/3/2005, Lordship. It was encashed. Now, Lordship, now page number 30, the letter, the forwarding which was, Lordship, addressed to Anil Todi, who is a respondent to, Lordship, it was acknowledged by the same person on the same date on page number 30A, Lordship. If you're, Lordship, may be pleased to come to 30A. It was received by the same person.
Who is appearing for respondent number 2?
Lordship, no one has appeared. Notice Lordship. must be good, Lordship. Steps are complete, Lordship.
No, notice have
Service completed, Lordship.
have okay, continue.
Now, Lordship, thereafter, Lordship, a complaint petition was filed. Lordship, summons was issued with the state persons and they were asked to be personally present. Lordship, if, and
No, after this, after you verified that the demand draft was encashed,
Lordship, the goods were never delivered.
thereafter what you did?
Lordship, never delivered. Lordship, we tried to contact the persons at Kolkata. However, Lordship, the office,
Then you lodged an FIR or you filed a complaint?
Lordship filed a complaint, Lordship.
Where is that complaint?
Lordship, complaint, Lordship, we had filed. Before the Lordship,
And you also preferred any civil remedy?
Lordship, civil remedies, Lordship, we have preferred. Lordship, it is in the last stage. Lordship, judgment will be delivered within this month, Lordship. Before in Dorong district,
Money suit?
Lordship.
Which
Lordship, the now,
number? What?
Lordship, I'll give
Okay.
that the end, Lordship.
You preferred a money suit also?
Lordship, now this is for
And
the,
also filed a complaint?
Lordship, for the criminal culpability of the respondent number 2, Lordship, especially. Lordship, the petitioner approached the
Where is
office.
the complaint petition?
Lordship, complaint case number 243 of 2014.
Where is
Lordship, it's
Page.
annexure 1.
page?
Lordship, annexure 1, page 21. CR case number 243 of 2014. Before the
Okay,
chief
thereafter what
Justice-
happened?
Lordship, thereafter, Lordship, summons was issued. Order of summons, if your Lordship, like,
Okay, then they appeared.
Lordship, they had appeared, Lordship, they had approached the High Court also, challenging the order of summons as well as the entire complaint case.
That was dismissed.
It was dismissed, Lordship, and the maintainability of the complaint case was, Lordship, affirmed by the Guwahati High Court. Lordship, if I may take your Lordship to that order, at page 43. Criminal petition 279 of 2015. Lordship, on the next page, order dated 24/5/2017. Here, Lordship, the accused persons had referred 482 application for quashing orders of 35/2014, by which summons was issued, 29/1/2015, by which, Lordship, they were asked to be personally present before the magistrate, as well as order of 24/3/2015.
Where is the impugned order?
Impugned order,
No, not impugned. That,
summons,
no, that order of the
High Court.
High Court.
Lordship, page 44 is the effective from which the order starts. Page 44.
Okay,
Lordship, this,
this is
yes, Lordship, the entire, Lordship, the orders issuing summons and
criminal petition.
as,
two-
Lordship, entire proceeding was challenged. Criminal petition, Lordship, 279 of 2000.
Thereafter,
Lordship, the state was dismissed. Lordship, which affirms that there is no illegality and the complaint petition thereafter, Lordship, continued. Lordship, after that, Lordship, they were issued non-bailable warrant arrest, Lordship, they were issued NBWA's lordship, against which again lordship the petitioner, the accused persons had approached the High Court lordship. That is lordship criminal petition lordship 879 of 2018,
What happened?
page 50 from page 56. Here lordship during the proceeding, lordship, if I may take your lordship to page 57, lordship, 2018. During the proceeding, lordship, the accused person was willing to pay the principal amount of 25 lakhs to the complainant. Page 57. The informant must be there, respondent must be there, lordship, as they have served the notice. Without him, lordship, the lordship, if the respondent has chosen not to, because there is some urgency matters pending, this wasn't
They have not appeared.
not appeared. One chance may be given, lordship. Otherwise, lordship, because the main impugned judgment constricts only to the question of whether there is territorial jurisdiction, lordship.
Only regard territorial.
Lordship, if I may take lordship to the main impugned judgment, lordship, because these are the facts. Lordship, maintainability has been affirmed by the High Court, lordship. Now, lordship, charges were framed against the accused respondent number 2.
Okay, thereafter. let's
Thereafter, revision petition was filed
Charge against the,
against respondent number 2, lordship, of the present
okay.
petition. There were two
When charges were framed,
lordship, page 72. Lordship, if I may read the charges, lordship, page 72. First charge is that
under section,
lordship under section 420, thereafter second charge under section 406, third charge under section 385. This was challenged in a revision petition before the learned sessions judge. Amongst various grounds, lordship, however, sessions judge, lordship, interfered only on the ground of territorial jurisdiction.
where did you pay that demand draft?
Lordship, demand draft was paid at Kolkata,
Kolkata, you went to
Kolkata. But lordship, the items were to be delivered at Mongoldo, lordship. Therefore, part cause of action. Also, lordship, if I may take your lordship to the averments, lordship, the accused person had very cleverly misled the district judge also. They had approached this Honorable Supreme Court for transfer of the proceedings from Mongoldo to Kolkata. But that was not annexed in the criminal revision petition. And that order, lordship, they had withdrawn without seeking any liberty to take up the same issue before any other forum, lordship.
Before Supreme Court.
Before Supreme Court, lordship, page number
They had
103.
withdrawn from this,
Lordship,
transfer application was withdrawn.
withdrawn.
Oh.
Page 103, lordship. And this was not annexed in the revision petition. Page 103, that is the last annexure. Dear Lordship, order dated 4/9/2018 before the Supreme Court of India. Here it says transfer petition is accordingly dismissed as withdrawn and no liberty was sought for, Lordship, to bring up the same issue before any other forum.
Okay, thereafter,
Lordship, now Lordship, coming to the impugn order.
which is at page
Lordship, impugn order is at page
95.
94.
What was the reasoning?
Lordship,
Let us go.
Your
to that.
Lordship, in page 96, paragraph number 4, several grounds, Lordship, and ground number 4 at page 97. It says, learned trial court, while framing the charges while order dated 12/11/2021, has failed to consider fact and law that the learned trial court does not have the territorial jurisdiction to entertain the complaint case, as no cause of action or part cause of action ever arose at Mongoldo Dorong, inasmuch as no payment made by complaint to any of the parties, as alleged was made at Mongoldo, against supply of any goods, and thus, in that view of the matter, the impugn order dated 12/11/2021 is liable to be set aside. Amongst all the grounds, Lordship, If your lordship may come to the finding, that is at page 101, lordship, of the sessions judge, lordship. Paragraph 15 says, I have considered the submission of the learned counsel for both the contesting sides, and I have also gone to the impugn order. I have come to the finding that no offense, if any, was committed within the territorial jurisdiction of the courts at Dorong district. The Court of Learned Chief Judicial Magistrate Dorong Mongoldoy lacked territorial jurisdiction to pass the impugn order dated 12/11/2021, framing charges against the petitioner. Next paragraph, in view of the above, I have come to the finding that the impugn order dated 12/11/2021 suffers from incorrectness, impropriety, and illegality, and hence the same is liable to be interfered with and set aside the same only on the ground of territorial jurisdiction, lordship.
What is your submission?
Lordship, my submission first of all is that the learned sessions judge had recorded the fact that payment was made at Kolkata, it was encashed at Kolkata. However, failed to record, lordship, in the same consequence, failed to record that the goods were to be delivered at Mongoldoy. Therefore, part cause of
Where is that agreement where it is stated that goods are delivered?
lordship, that is in the letter, lordship, page number 30. This is a translated portion. Second paragraph, lordship. I
30A.
request you to dispatch page 30. In the second paragraph, I request you to kindly dispatch so and so within 20 March 2005 to carry the same from Kolkata to Mongoldoy, Assam. It's very clear, Lord.
And how this demand draft was sent
Lordship, at the office at Kolkata. Petitioner had
person?
in person, Lordship.
Okay. So the demand draft was actually paid in Kolkata.
Kolkata. An entire transaction continued till Mongoldoy until the goods were
Yes,
delivered.
now make your submission.
Now, my lordship, since lordship, the learned session judge has interfered only on the ground of territorial jurisdiction, lordship, will constrict our arguments only to that, lordship. Lordship, first of all, lordship, regarding the transfer petition at Supreme Court. The Honorable Supreme Court, lordship, although in the court, lordship, a transfer petition was filed, lordship, it was withdrawn with seeking no liberty. Therefore, lordship, the accused person had no lordship forum before him to again take up the same issue. Lordship, the rules of constructive.
No, they are not paying for transfer.
Lordship, this is a transfer petition. Page number 103.
No,
That is on
in Supreme Court, they have filed transfer
transfer
petition, which they have withdrawn.
withdrawn.
They are not approaching any court for the second time
No, but lordship, the grant was taken the revision petition, lordship.
that you lack jurisdiction.
Lordship. And they had
Not
themselves
paying for
withdrawn.
transfer.
No, but they had themselves withdrawn the same, lordship. They have filed in the Supreme Court and
No,
withdrawn.
they might have withdrawn.
Lordship. And without seeking liberty to bring up the same issue again before any forum, lordship.
No, but they are not raising that transfer matter.
Lordship,
They are only raising that this court lacks jurisdiction.
jurisdiction. But
So
lordship,
there is a difference between filing a transfer petition
lordship,
and pleading that a particular court lacks jurisdiction.
but lordship, ultimately,
In Mongoldoy, their plea was Mongoldoy court lacks jurisdiction,
Lordship.
which was upheld by which was the ground on which the
Right.
revision was allowed by
lordship,
sessions court. Now, what is your submission to that?
lordship,
How
regard,
withdrawal of transfer petition affects that fact?
lordship, withdrawal transfer petition directly affected because here, lordship, it's the same issue ultimately. Lordship, first of all, they approached the Honorable Supreme Court for transferring the
Assuming
entire case, lordship.
they might have withdrawn thinking that there is no necessity of transfer because the case would otherwise not go
Lordship.
beyond the stage of framing of charges. They may be hopeful of getting discharge order because they knew that this court lacks jurisdiction. That may be ground for withdrawing the
Lordship,
transfer
that is, Lordship, that is there, but however, Lordship, res judicata, Lordship, the principle of res judicata, Lordship itself, Lordship, propounds,
Oh.
Lordship. And also
Oh.
res judi- Lordship, this is one ground, Lordship. The other ground which I would like to satisfy,
No, what is your ground? What is your submission?
Lordship, first ground
Because the transfer petition was
was
withdrawn
withdrawn
liberty.
without seeking liberty, Lordship.
So
Therefore, Lordship, the plea of lack of territorial jurisdiction could
Cannot
not
be
have been brought up, Lordship, again.
okay. This seems to be weak argument.
Lordship,
You have authority.
Lordship, I have an authorities at rest constructive Lordship, constructive rest judicata is applicable in criminal laws, Lordship. Supreme Court, Lordship, has clearly enunciated the same on this.
But the issues are not same. Okay.
But ultimately,
Your
Lord,
submission is that transfer petition was withdrawn
Lordship,
without seeking liberty.
Lordship,
So they could not have taken plea of lack of territorial
for any other
jurisdiction
forum,
before any other.
forum.
Okay.
That is one ground. Lordship, the second ground, Lordship, regarding the items which were to be delivered at Mongoldoy. Payment may have been made at Kolkata.
Okay, now
But-
yes, that is important.
No,
On-
second ground. Payment may have been made at Kolkata, but the Lordship transaction was continuing till Dorong because the goods were to be delivered at Dorong, Lordship. This aspect was not looked into. Only the first aspect was looked into. That payment was made at Kolkata. But Lordship, what about the aspect that it was to be delivered at Dorong? Lordship, part cause of action arose at Dorong also, Lordship. And Lordship, regarding this, Lordship, regarding jurisdiction, Lordship, there is a recent judgment of 2020 of the Supreme Court. Lordship.
Yes, what is the citation?
Lordship, 2020, volume 10, SEC, page 92.
Yes,
Lordship, if I may read
Yeah.
from paragraph 17 onwards, Lordship, very clearly the court has, Lordship, dealt with this issue.
yes, please read.
From paragraph 17. Here, Lordship, the court has distinguished between territorial jurisdiction in civil cases as well as criminal cases. If I may line onward of paragraph 17. The question of territorial jurisdiction in criminal cases revolves around, Lordship. 1. Place of commission of the offense.
Yes. Para 17.
Para 17. Page 10.
Which line?
From the 6th line onward, Lordship. The question of territorial jurisdiction in criminal cases revolves around 1. Place of commission of the offense, or place where the consequence of an act, both of which constitute an offense, ensues. Consequence of the act, Lordship, he had, by false impersonation, he had taken the money, Lordship, but he had not delivered it Mongoldoy. Consequence, Lordship, ensues in Mongoldoy from this. Or place where the accused was found, or place where the victim was found, or place where the property in respect of which the offense was committed was found, or place where the property forming the subject matter of an offense was required to be returned or accounted for, according to etc., as the case may be. Next paragraph, again from the Lordship, second line, jurisdiction of a criminal court is determined by offense and secondly offender. Now, Lordship, here, Lordship, from in again paragraph 18.2. In criminal proceedings, a limited power is available to a magistrate under section 201 of the Criminal Procedure Code to return a complaint. The power is limited in the sense that is available before taking cognizance. And secondly, limited only to complaints. Lordship, For return a complaint, Lordship, it ought to have been, Lordship, availed of before taking cognizance, as per section
Yes,
201.
what was done? Your complaint was returned.
No, Lordship.
It was
Cognizance was taken, summons was issued there.
the respondent number 2 was discharged.
Accused number 2 was discharged. Accused number 1, who is a respondent number 2 of the present petition, Lordship, charges were framed.
Okay. Charge was framed.
Lordship, against the rest.
So you are against the discharge of accused number 2.
Lordship. No, Lordship, I'm against the Lordship, the order which
Oh,
set aside,
decision
which had said, Lordship, I'm for the complainant, Lordship. Now, Lordship, from paragraph 20 onward, the principles laid down in sections 177 to 184 has been enumerated clearly by the Lordship. Paragraph 20.3, Lordship, I'll be reading here. When offense is committed partly in one area and partly in another, it may be inquired into or tried by a court having jurisdiction over any of such local areas. Part cause of action, Lordship, is covered by this. 20.4. In the case of a continuing offense which is committed in more local areas than one, it may be inquired into or tried by a.
What is the offense which you are alleging?
One is that, Lordship, Lordship, he encashed a check,
No,
used it for his own whatever purpose, Lordship, and
no. What is the provision?
Lordship,
Criminal breach of trust.
Lordship, 3 sections.
What are those sections?
Criminal breach of trust under
Section
406.
406.
And cheating and dishonestly inducing delivery of property, which is the demand draft under section 420. Also, Lordship, extortion under 385, because, Lordship, in the year 2013, Lordship, the accused number 2 had approached the complainant, wherein, Lordship, he had blackmailed him, saying that, Lordship, he will reveal some sensitive data or information regarding him if an amount of his 5 lakhs was not paid, Lordship. Therefore, 385 as well.
No, charges were framed against accused number 1, accused number 2.
Lordship, accused number 1, Lordship, accused number 2 was discharged.
Accused number 1
Lordship.
under all these 3 sections.
Lordship, I'm coming to that.
Okay, no, let us first, you complete this citation part.
Yes, Lordship. 20.4, Lordship, in the case of a continuing offense which is committed in more local areas than one, it may be inquired into or tried by a court having jurisdiction over any of such local areas. 20.7. In cases where an act is an offense by reason of its relation to any other act, which is also an offense, then the first mentioned offense may be inquired into or tried by a court within whose local jurisdiction either of the act was done. Act of not delivering is an offense. Its relation to the first offense, that is, Lordship, encashing the demand draft with the intention of not delivering, Lordship. Therefore, this, Lordship, falls. Now, Lordship, 20.11 on the next page. Lordship, this hearing must be done in with the informal respondent number 2, Lordship. We are formal, Lordship. So he will require, Lordship.
Suppose he does not come,
One chance, Lordship, because everything he will be,
we'll give him.
Lordship, for that.
No, let her complete her.
Otherwise, no. Otherwise, Lordship, if your Lordship allows this, Lordship, trial will continue, Lordship. And wrongly, Lordship said, I said, Lordship, now 20.11. An offense of criminal misappropriation or criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offense was committed or any part of the property was received or retained or was required to be returned or accounted for by the accused person. Any part of the property was received or retained or required to be returned or accounted. Lordship, they cannot deliver.
Where?
Lordship, 20.11.
Okay.
Lordship, an offense of criminal misappropriation or criminal breach of trust may be inquired into or tried by a court within whose local jurisdiction the offense was committed or any part of the property was received or retained, Kolkata, or was required to be returned or accounted for in Dorong by the accused person.
But this is in your favor.
Lordship, 20.14 also. An offense of cheating and dishonestly inducing delivery of the property may be inquired into or tried by a court within whose local jurisdiction the property was
This
delivered.
is also in your plan.
Lordship, person deceived or was deceived by the accused person. Now, Lordship, paragraph number 24, Lordship, in the next page, page 13. Section 462, which is a saving clause of it.
Yeah.
No finding, sentence, or order of any criminal court shall be set aside merely on the ground that the inquiry, trial, or other proceedings in the course of which it was arrived at or passed took place in the wrong sessions division, district, subdivision, or other local area, unless it appears that such error has in fact occasioned a failure of justice. No failure of justice, no averment regarding the same, Lordship. Therefore, our case is saved by section 462 also, Lordship, of the CRPC. In paragraph 36, the Honorable Supreme Court's finding, Lordship. Two different types of jurisdictional issues. This court concluded in that case that where a magistrate has the power to try a particular offense, but the controversy relates solely to his territorial jurisdiction, the case would normally be covered by the saving clause under section 531 and present 462 of the
This
1970
is after culmination of trial.
Lordship.
Okay, now what was the reasoning of the session judge
Session judge,
in
Lordship.
holding that there is no territorial jurisdiction? He has not discussed in,
No discussion. Only Lordship has come to the finding that no offense
he
was
have
committed.
discussed the submission,
Submissions were discussed, Lordship.
but his own analysis is not there.
No analysis, Lordship. And interfered only regarding territorial
Okay,
jurisdiction.
now how the notice was served on respondent number 2?
Lordship, by way of Lordship postal talabana and Lordship as per the track consignment, it was received and the Lawazima court also acknowledged the same, Lordship. Because Lordship, the accused persons from the beginning, they are trying their best to delay the proceeding. From 2014, it is pending. Numerous litigations, Lordship, and all of them were dismissed.
Where is the order of, let us see,
Not, sir.
service of notice? Kalla.
Lordship, ordered it in 19/8/2024.
Okay. So we have heard, you have any submission?
Lordship, let us see, Lordship, one.
We'll fix it next
and-
week also.
Lord-
If they don't appear, we'll get, I have heard you,
Lordship.
we'll fix it in the next week on a date to give them a chance so that they appear. Otherwise, we'll dispose it of.
Lordship, Lordship may be marked as a part head. 2 weeks.
No, I'll not mention Partha.
Otherwise, Lordship, in all the proceedings, if your Lordship notices from 2014, only delaying mechanism. And all their Lordship litigations were dismissed.
No, we'll give them a chance.
Lordship. Otherwise, if the state has any objection in this petition, Lordship, they can. If the state has no objection, Lordship, even that can be Lordship recorded. Let the fix that.
Heard Miss R. Burwa, Lanet,
P. Barwa.
heard Miss P. Burwa, Lanet counsel for the petitioner. Also heard Miss A. Begum, Lanet additional public prosecutor. None has appeared for respondent number 2. Though from order dated 28/8/2024, it appears that notices were duly served on respondent number 2, and there is an order of this court regarding due service of notice on the said response. However, for the ends of justice, one more opportunity is granted so that to the respondent number 2. Stop. Hence, let this case be listed again on suggested date.
Lordship on 14th next week. Or Lordship, if it's a hearing day, maybe Lordship on 20th November, on a Wednesday.
On 20 November.
But Lordship, since
No, no, it has
that
to be,
length, Lordship may mark it as part, Lordship. My humble request, Lordship.
there is a catch. If I reflect it, that I have already heard, making it, if the respondent number 2 appears on next day, you may have to make
Lordship, then I'll make the submission, Lordship, again.
submissions again.
Lordship, that goes without us saying, Lord.
On, let it be then on a hearing date.
Lordship on 14th in that case, 14 November. 21, Lordship, then. 21,
On 21
Twen-
November as
Right.
part of.
deeply over.
Yes.
Lordship, item number 12 may be taken up after 2 weeks. Lordship. I've taken content from it. Some instruction is required. Lordship. They have challenged the order of the Planet Special Judge. Lordship. And where Lordship APSA will be regarding to APSA Act, Lordship. Armed Force Special Power Act, Lordship. Whether that was in force at the time of occurrence, that is required to be ascertained, Lordship. We have wrote to the government, and that has not been, as on that it has not been supplied to the copy of the. We need
Do
some
you have
time.
any objection?
No objection.
Heard Mr. R.K.D. Chaudhary, learned counsel for the petitioner. Also heard Mr. M. Haloy, learned special public prosecutor appearing for CBI, who prays for an adjournment for 2 weeks on the ground that he has to take
Instruction
some instruction
with regard to.
with regard to what?
With regard to, already, there is the order on the last occasion of that.
Now with regard to what? Let it be on record.
Yes, yes. With regard to the. To ascertain whether APSA Act, Armed Force Special Power Act, is in force or not during the period of when the occurrence took place.
To take instruction as to whether the Armed Force Special Power Act, which is the year
2000. 2001.
2001, was in force
No,
when the
Lordship, Act is not of 2001. The incident is of 2000.
APSA Act is highlighted, was in force when the
Incident.
offense alleged in this case occurred.
Act is of 1958.
in TP.
Act
It
is of
was, it is still in force, but
No,
whether
no,
in that
but how-
area,
Yes.
in that particular area. Learned counsel for the petitioner has not opposed the prayer. Hence, let this matter be listed after.
We have copy of some orders were given. Where for a particular period, there is no mention with regard to the applicability of APSA. So that needs to be,
If APSA is applicable, then
then he has,
you will get, he has no protection.
he has protection.
Yes.
We have no.
What is your case?
In fact, Lordship,
Sanction is required.
sanction is without a prior sanction under the section.
Sanction is required because of APSA.
Because it was an army operation at that point of time. Their case. That is our
After two,
and Lordship, there's an interim order.
the interim order shall proceed.
It's on 18, Lordship. Let it be. On
No,
18.
let it be on,
No, Lordship. I do not have any objection. Any
okay, let it,
on 18.
list the matter on instead of 2 weeks. let the matter be 18.
So nice.
put it. None has appeared for the applicant, appellate or court. Learned Mr. R. Kaushik, learned additional to perfect. Let this matter be stayed. Without
Only 2 minutes left, my lord.
we'll wait till
That's for prayer.
topic wait. Improve to the
May I please your lordship? Lordship, FIR starts from page number 14, your lordships. Lordship may kindly peruse page number 17. So the allegation, wife of the petitioner lodged an FIR, your lordship, in physical harassment, your lordship. And petitioner is the ward commissioner of a town committee, your lordships.
what is 8988?
Lordship, 88 is causing miscarriage, 89 is causing miscarriage without consent, and 109 is attempt to murder, your lordship. And wife of the petitioner lodged an FIR, your lordship. Relevant portion is page number 17 and 80, your lordship.
Page number 17.
And
Is the
18, your lordship.
complaint.
Yes, lordship, complaint.
What is the allegation?
Allegation, lordship, physical assault, your lordships. And
This is a complaint case or FIR has
lordship is here the complaint case. And
Yes.
after completion of the investigation, FIR has been lodged, your lordship.
okay, complaint was forwarded as an
Yes,
registered
lordship.
as-
Yes, lordship. It's page number 15. The order of the magistrate is here, or not.
Yes, what is
Lordship, my submission is that we- petitioner and the accused petitioner and victim girl was married on
you were husband and you are
when it has been right. Page number 12 is the relevant portion, your lordship. We are married couple, your lordship. After our marriage, the victim girl, the wife of the petitioner, want to separate accommodation, your lordship. And he repeatedly denied for separate accommodation because he has elderly parents and she had an extramarital affair, lordship. I've written all these things in page number 5, your lordship, paragraph number 7, your lordship.
no, regarding miscarriage.
Miscarriage, lordship, I have and all the relevant document for the medical document, your lordship, as page number 20, your lordship. See, she had some gynecological problem, your lordship. Lordship may protect me. I will appear before the. Is there anything against me, your lordship? Lordship may can
24. No, on 25/10/2024. The victim woman who is the wife of the present petitioner, had approached the chief judicial magistrate where Shankardev Nagar, Hojai, by filing a complaint against the present petitioner alleging commission of offense under aforementioned sections. This stuff by order dated 30/10/2024. The complaint was forwarded to the officer in charge of Hojai Police Station to register a PS case. Stop. Accordingly, the Hojai PS case number 326/2024 was registered. The victim has alleged that she was subjected to physical and mental torture by the petitioner after her marriage with him. She has also alleged that she was pregnant by 2 months, that while she was pregnant by 2 months, on 1/9/2024, the petitioner had assaulted her. Stop. It is also stated that the petitioner kicked her on her belly as a result of which she suffered pain and bleeding and miscarriage occurred. She was not taken to any doctor by the petitioner. It is also alleged that the petitioner gave one misoprostol tablet, misoprostol 200 tablet, and some other painkiller tablet to the complainant. It is further alleged that on 21/9/2024, the petitioner again assaulted the victim, assaulted his wife at night, and thereafter the victim called her family members, and with the assistance of police, he was recovered from her house, from her matrimonial house. However, the petitioner fled away from. What is your submission? Learned counsel for the petitioner has submitted that the allegations leveled against the petitioner in the complaint in the affair are not true. Any other submission?
There is a domestic quarrel between wife and husband here, okay. And she has an extramarital affair. Lordship. I have obtained page number 5, your lordship.
The learned counsel for the petitioner has also submitted that the wife of the petitioner had extramarital affair with whom? Have not. And there was domestic quarrel between, and there was only quarrel between them. On the other hand, learned additional public prosecutor has vehemently opposed the grant of anticipatory bail to the present petition on the ground that the bare perusal of the affair would reflect the involvement of petitioner in the alleged offense, and the fact that the petitioner assaulted his wife while she was pregnant is clearly stated in the FIR, hence he opposes the grant of bail. On the other hand, learned counsel for the informant. Informant is the victim. Lordship. Informant is the victim. Victim has also vehemently opposed the grant of bail, stating that the petitioner was mercilessly beaten up while she was pregnant, and this is not a case. This is not a fit case where the benefit of section 482 of ANSS may be given to the petitioner. He has produced a photograph of the victim girl, which shows the mark of violence on the body of the victim. So I have gone through the submissions made by learned counsel for both the sides and have perused the materials available on record. Available on record. Considering the nature of allegation leveled against the petitioner, as well as the materials available on record which suggest that the victim was beaten up. Stop. Beaten up merciless. Stop. Comma. This court is of considered opinion that this is not a fit case where the benefit of a favorable order under section 482 of the BNSS may be granted. Hence, the prayer for grant of bail.
Deep privilege, Lordship.
Ready?
Look, I am ready, but unfortunately, last order may kindly be seen. I am directed to take fresh steps on
Okay.
the respondent.
It is a POXO matter.
Huh? No.
Who is respondent number?
He's the informant. Nowadays, informant has to be made a party, but when the appeal was filed, Your Lordship, that order was not there to treat the informant as a respondent.
What is the matter?
The appellant before Your Lordship was convicted under section 304, part 2, and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 25,000 and in default to 6 months for the rigorous imprisonment. 304 part 2.
Mr. Kaushik, you are ready? In 304 also victim has to be made party.
Actually, my knowledge goes on, this is not meant compulsory.
It is compulsory now.
It's compulsory.
Yes.
Where is the
nowadays.
provision?
No, that is reflected in earlier order. Because this matter was listed for hearing and I was ready to argue, then Lordship.
Victim need to be, they need to be made party, but their participation is perhaps my lord.
Which order? Which order?
Let me can this. Last. No, order dated 9/9 subject to correction of 2022. I was directed to take step. This was by Honorable Mr. Justice M. Chaudhary.
Yes, no, direction is there, but where is the requirement? This is not a case under POXO.
Okay, yes,
It is not a case.
definitely.
What was the allegation?
Allegation, Your Lordship, was that
Who is the victim?
victim is the deceased, my lord. Victim is one Kulu Hendik.
What is your relationship with?
No, listen, my lord. The allegation is basically as per the FIR. That was
Then whether notice is necessary?
My lord, so far my knowledge goes, my lord, they need to be made party. But like,
No, but if no, what is the law? Because somewhere I have found.
Yes.
If someone is made party.
Yes.
Then it is obvious that notice has to go.
Has to.
But
Here what happens, if I'm not wrong, initially my learned friend didn't make them any party.
Yeah, because at that point of time,
At that
that was
time,
not
there is a judicial.
requirement.
Yes, but subsequently he made a party. Since he made a party, then obviously notice has
Because
to
as per the
go.
honorable court direction, I am implemented him as a respondent number 2.
But
And
the
that was
thing
the
is-
Have you
directive.
taken steps?
Yes, earlier I have taken steps that was due to insufficient address, that notice is returned back. So I am directed by last order. Unfortunately, I was not present that time. So OC, I was directed to serve the notice on 28/10/2024.
Yes, you have not taken steps.
No, earlier I have taken, but now
Through
this
OC, through OC,
Duryazan.
you have taken steps.
No, today I come to know on
Then
last
you-
question I
then
was
you have to
absent of
take steps.
unfortunately. I will take steps.
After receiving the step, if they don't appear, then this court can
Then
proceed.
yeah,
Yes,
can proceed.
then
Yes,
Then this court can proceed.
that can,
heard Mr. D.K. Chomal,
yes, sir.
learned counsel for the appellant, also heard Mr. R.R. Patrick, learned counsel for the appellant has submitted that due to inadvertence, the petitioner, the appellant could not take fresh steps as was directed by order dated 28/10/2024 by this court, and seeks some more time to take step in pursuant to the state order. Where is that up? The appellant shall take steps within 7 days from date of this order for service of notice on respondent number 2 to the officer in charge of jurisdictional police station. The notices are returnable on after. Let me get. Yeah, but I can. Returnable on. Fourth of. Fourth of.
Ready as